The hangar at AeroCrown Aviation occupied the northeastern corner of the regional airfield and was large enough to contain 3 full-frame aircraft in parallel. Malcolm Vance had been in it before, twice for initial meetings, once for the technical demonstration that had preceded the contract talks. But he had never stood in it the way he stood in it on the morning of the presentation, which was as someone who understood that the room was designed to make a particular impression and that the impression was being used against him. Richard Ellison, AeroCrown's chief executive, had arranged the room with specific attention to the positioning of the chairs. The seats for Malcolm and his 2 engineers were on the side of a table that faced the hangar's full length, which meant that behind Ellison's presenters, at a distance that was not overwhelming but was impressive, sat a partially assembled long-range executive aircraft that had not been there on any of Malcolm's previous visits. The aircraft was there to communicate something about the scale of what AeroCrown was and could do. The communication was deliberate and correct. Malcolm had grown up watching his father build things. Leon Vance had worked as a machinist for 29 years and had taught Malcolm, in the way that people who work with their hands teach the people they love, to understand the relationship between precision and function. Malcolm had learned to read engineering tolerances the way his father read them, as statements about what a component would do and what it would not do, with no margin for wishful interpretation. He had taken this reading into his own work when he founded Vance Precision Engineering, and he had taken it further when he invented the Vance stabilizer coupling, which was a vibration-dampening component with applications in aerospace systems that operated at the specific intersection of tolerance and load that most comparable components failed to maintain over sustained use. The coupling was patented. Malcolm held the patent. AeroCrown needed the coupling for a next-generation aircraft stabilization system that was central to a contract with the U.S. Department of Defense worth $500 million. There was no certified alternative supplier. The coupling specifications were precise enough, and the certification process long enough, that bringing a new supplier to certification would take between 18 and 24 months, which was longer than the contract timeline allowed. This was the position Malcolm Vance occupied when he sat down at the table in the hangar. AeroCrown needed what he had. He had spent 6 years developing what he had. The patent was his. The certification was his. The coupling was his. What happened next in the room would later be described in the County Superior Court filing, in the arbitration documentation, and in the AeroCrown Board's independent audit as a coordinated negotiation tactic. In the room, it felt like humiliation. Ellison's lead attorney was a man named Graham Sutter, who had been doing aerospace contract work for 22 years, and had a practiced fluency with the language of technical specification that he used to create. In people who were not attorneys, the impression that the technical and the legal were the same thing, and that he inhabited both with equal authority. He presented the proposed contract language for 45 minutes. The presentation covered component specifications, delivery schedules, quality assurance requirements, liability provisions, and a section on intellectual property licensing that Sutter described as standard practice for integrated component suppliers in this category. Malcolm's 2 engineers were taking notes. Malcolm was listening to Sutter and also watching Ellison, who was at the side of the room with 2 senior vice presidents, neither of whom were contributing to the presentation. Ellison was watching Malcolm with the specific attention of someone who is waiting for the moment when the person he is watching realizes something. The intellectual property section of the proposed contract language was on page 17 of the 32-page document that had been provided to Malcolm's team on a tablet at the start of the presentation. Malcolm had not yet read page 17. He was hearing it summarized by Sutter, who described it as a standard provision that granted AeroCrown a perpetual worldwide transferable license to the stabilizer coupling technology as integrated into AeroCrown systems, with the further provision that any improvements or adaptations made to the technology in the course of the integration would be jointly owned by AeroCrown and Vance Precision Engineering, with AeroCrown holding the right of first refusal on any subsequent licensing. Malcolm said, "Read that again." Sutter read it again. Malcolm said, "You're asking me to give you a perpetual worldwide transferable license to my patent," Sutter said, "as integrated into AeroCrown systems, yes. And any improvement I make to my own technology in the course of this contract becomes jointly owned." "That's correct, with the first refusal provision. So if I improve my own invention while I'm working with you, you own half of the improvement." Sutter said, "That's a simplified characterization, but yes. Malcolm looked at the tablet in front of him. He looked at page 17. The language was dense and precise in the way of contracts written by people who specialize in dense precision, and it said exactly what Sutter had said it said. He was being asked to, in exchange for the revenue of the AeroCrown contract, give AeroCrown a permanent claim on his technology and on the future development of his technology. He said, "This isn't a component supply agreement. This is an acquisition." Ellison stepped forward from the side of the room. He was 58 years old and had been running AeroCrown for 12 years and had the particular quality of the CEO of a large company. The assumption, continuous and not quite conscious, that the room was arranged for him. He said that they would not characterize it as an acquisition, and that they understood that the language might seem aggressive on a first reading, but that it was standard in the industry for integrated suppliers, and that he hoped Malcolm would consider it in the full context of the partnership they were proposing. Malcolm said, "I've reviewed dozens of integrated supplier agreements in this industry. This language is not standard." Ellison said, "In our category it is." "Then you can produce 3 examples from the last 5 years with equivalent language." Ellison looked at Sutter. Sutter began to speak about category-specific precedent. Malcolm said, "Specific examples with names." Sutter did not produce specific examples with names. The meeting continued for another 30 minutes. Malcolm's engineers were quiet. Malcolm asked questions throughout and received answers that were either technically inaccurate or strategically evasive, and he noted each instance specifically enough that the noting itself became a form of pressure. At the end of the 30 minutes, Ellison said that he hoped they could move forward constructively and that the contract was designed to work for both parties, and that he was sure there was flexibility on some of the specific language. Malcolm said, "I'll have my attorney review it." Ellison said, "Of course. We'd ask for a response within 10 days given the contract timeline." Malcolm said, "I understand the timeline." He took the tablet with the contract document on it. He shook hands with the people who shook hands. He walked out of the hangar with his 2 engineers. They crossed the airfield to the parking area and got into the truck and sat in it without moving for a moment. One of the engineers, a man named Jordan Miles, who had been with Malcolm for 3 years, and who was 29 years old and had come to Vance Precision on a scholarship that Malcolm funded for engineering students from his county, said, "Page 17 is designed to take your company." Malcolm said, "Yes, they need you. They can't use anybody else. They know that." Miles said, "So what do they have?" Malcolm said, "They have $500 million and the patience to wait. They think if they can delay long enough, I'll run out of money before they run out of time." Miles said, "Is that possible?" Malcolm looked at the airfield. He said, "Let's call Naomi." Naomi Vance was his daughter and a corporate attorney with 12 years of experience in intellectual property and technology contracts. She was 37 and had built a practice that specialized in exactly the kind of situation that page 17 represented. She had not been at the presentation because Malcolm had not known the presentation would produce a page 17 situation. He called her from the parking lot. He described the provision. She asked him to take a photograph of page 17 and send it. She read it. She called back in 8 minutes. She said, "This is not standard." "I know. They'll argue it's standard. They'll find contracts that have similar language. Sutter couldn't produce examples in the room. He'll produce them later. The question is whether the examples are genuinely comparable." She paused. "The bigger question is timeline. They have leverage on the timeline. They've given us 10 days. We need more than 10 days to analyze the full document and build a response. I'm going to request 30. They'll say no. We'll negotiate to 15 or 20. During that time, I need you to be thinking about what you're willing to do if they don't move." Malcolm said, "They need the coupling. They need it by the contract deadline. If we get past the deadline, the Department of Defense will begin looking for alternatives. They'll put pressure on AeroCrown. At that point, AeroCrown's leverage reverses. They're the ones who need you before a federal contract deadline, not the other way around. That assumes they don't have a secondary play." Naomi said, "What are you thinking?" "I'm thinking they may try to move the certification for an alternative supplier faster than the timeline suggests is possible. If they can get a provisional certification, they can use that as a negotiating chip." Naomi was quiet for a moment. Then she said, "Can they do that?" "Not honestly. The certification process requires specific testing timelines. But the certifying body's independence has been a question in the industry for a while. I'll look into who sits on the certifying board." Malcolm said, "Rebecca Shaw." "What?" "She audits aerospace contracts for the Department of Defense Inspector General's office." I met her at the trade show in Chicago 2 years ago. She told me the certifying process had been flagging pressure issues from large contractors. She was conducting an analysis. Naomi said, "Call her." Rebecca Shaw answered on the second ring. She was in her office. She said, "Malcolm Vance, I was going to call you." This was the sentence that Malcolm, reconstructing the morning's events later, would identify as the first indication that the morning was not going the way AeroCrown had intended. Shaw's investigation of pressures on the aerospace certification process had, in its development over the preceding year, produced specific documentation that included AeroCrown. The documentation was part of an Inspector General report that was in final review and had not yet been released. Shaw could not share its contents. She could confirm that it existed and that Malcolm's situation was something she would need to speak with him about on the record, with appropriate counsel present as part of a formal inquiry. Malcolm said, "When?" She said, "As soon as you can arrange it." The formal inquiry took place 4 days after the hangar meeting. Naomi was present. Shaw was joined by an attorney from the Inspector General's office and a Department of Defense contracting officer. They sat in a conference room at a neutral location, and Malcolm answered questions about his interactions with AeroCrown, the proposed contract, and specifically about a meeting that had taken place in Ellison's office 6 months before the hangar presentation, at which certain representations had been made about the coupling's integration requirements and the contract's IP provisions. Malcolm had recorded that meeting. He had recorded it because the meeting had felt, in real time, like a meeting where a record would matter. He had a small digital recorder in his jacket pocket, and he had turned it on when he sat down. He had not told anyone he had recorded it. He was not certain the recording was legally usable, but he had the recording, and what it contained was Ellison, in his own voice, describing to Malcolm how AeroCrown intended to use the contract to secure the technology, in a way that gives us the development rights without triggering the acquisition costs, which was the sentence that Shaw's attorney, hearing the recording for the first time, sat back in her chair and did not immediately speak. Malcolm said, "Is that useful?" She said, "We'll need to verify the provenance and confirm the state's recording laws apply. But yes, that's useful." Jordan Miles testified in the subsequent proceedings. He was 29 years old and had grown up in the county and had attended college on the scholarship that Malcolm's company funded, which had been established by Malcolm in his 3rd year of operations, specifically for engineering students from the region who did not have the financial pathway to the education their ability warranted. Miles had taken the scholarship, completed his degree, and come to work at Vance Precision because he had believed in what the company was doing. He testified about the presentation, about page 17, about his immediate assessment that the language was designed to acquire the technology without the acquisition price. He testified with the precision of an engineer, which is to say that he described what he had observed and did not characterize what he had not observed. He was asked whether he had formed an impression of AeroCrown's intent from the presentation. He said, "The provision was written to achieve a specific outcome. Whether the intent was to achieve that outcome deceptively or whether AeroCrown believed it was standard practice, I don't know. I know what the provision would have done. What the provision would have done was transfer to AeroCrown, over the life of the contract and its extensions, effective control over the coupling technology and its development trajectory. Malcolm's patent would have remained his, technically. His ability to develop or license the technology independently would have been progressively constrained by the joint ownership of improvements and by AeroCrown's right of first refusal on licensing, until the patent itself was primarily valuable as a historical artifact of what had once been a fully independent invention. This was not illegal on its face, which was why Sutter had described it as standard. It was the kind of provision that was used successfully many times in aerospace contracting, with suppliers who were less aware of what they were signing, or who were in a financial position where the immediate revenue of the contract outweighed the long-term cost of the provision. Malcolm Vance had been in neither of those positions, and the morning in the hangar had been the moment when AeroCrown found this out. The AeroCrown board received the Inspector General's preliminary findings 9 weeks after Malcolm's formal inquiry. The findings included the recording, which the Inspector General's office had reviewed and determined was captured in compliance with applicable law, and the documentation from Shaw's investigation of the certification process. The findings also included an independent review of AeroCrown's contracting history with smaller suppliers, which showed a pattern of IP provision language that had produced, in 7 documented cases over the preceding 8 years, exactly the kind of progressive technology transfer that page 17 would have produced with Malcolm. The board met. Ellison was not present for the portion of the meeting where the findings were discussed. He was asked to resign. He resigned. The board named an interim chief executive and issued a statement that the company was committed to reviewing its contracting practices and to full cooperation with the Department of Defense inquiry. The interim CEO contacted Naomi Vance the day after the board's announcement. He asked for a meeting. Naomi said the meeting would need to be at her client's location. He agreed. The meeting took place at Vance Precision Engineering's facility, which occupied a building that Malcolm's father had worked out of for the last 6 years of his career, as a contractor doing specialized machining work. When Leon Vance retired, Malcolm had bought the building from the owner and had expanded it over the years to accommodate the coupling's manufacturing requirements. The building had Leon's tools in a display case near the entrance, put there by Malcolm not as a museum piece, but as daily reminder of what the work was grounded in. The interim CEO sat across the table from Malcolm in the facility's conference room. Through the window behind Malcolm, the shop floor was visible, the machines, the people working, the careful, precise environment of a manufacturing facility where the tolerances were specific and the workers who maintained them had been trained to understand exactly why the tolerances mattered. The new contract language did not contain a page 17 provision. It contained a standard licensing arrangement for the specific application of the coupling in AeroCrown's integrated system, with a term that matched the contract period and renewal options that required mutual agreement. Naomi had drafted the final language. Sutter was no longer AeroCrown's attorney. Malcolm read the contract. He asked 2 questions. The answers were satisfactory. He signed. The interim CEO said, "We want to build a long-term relationship." Malcolm said, "The relationship starts with what you do next, not with what you say now." The CEO nodded. He understood. He was in a room that understood something he was still learning, which was the relationship between what a company says about itself and what the record of its behavior actually shows. That the people who had built the record and survived the gap between the two were not going to stop paying attention to it. After the CEO left, Malcolm stood in the conference room for a moment. Jordan Miles came to the door and said they were ready on the floor to run the day's production. Malcolm said he'd be there in a minute. He looked at the shop floor through the window, the machines, the people, the precision. He thought about his father. He thought about the tools in the display case by the door. He thought about what Leon Vance would have said about the morning in the hangar, and about page 17, and about the recording in the jacket pocket, and about Naomi on the phone in 8 minutes, and about Shaw who was going to call anyway, and about Miles testifying with an engineer's precision, and about the interim CEO sitting in the conference room, where the shop floor was visible through the window. He thought his father would have said, "You built something real. Real things don't yield to paper." He went to the floor. There was work to do, and it was the work he had built the company to do, and the company was still his, and the work was still his, and the coupling was still his, and the patent was still his, and his father's tools were still in the case by the door, and the day was running, and the tolerances were being met, and the record of what had almost happened was filed in federal offices, and in the board's audit report, and in Miles's testimony, and in the audio of Ellison's own voice describing what AeroCrown intended to take. None of it had been taken. The morning in the hangar had been designed for a specific outcome, and the outcome had not occurred, because the person in the room had understood exactly what was happening and had started calling people from the parking lot. That was the whole thing, knowing what was happening, starting the call. Malcolm Vance went to the floor. The machines ran. The coupling was made with precision that had no margin for wishful interpretation, because that was what his father had taught him, and it was what he had taught the people on the floor. And it was what the coupling required, and the coupling was real, and real things were what they were, and what they were could not be rewritten on page 17 of anyone's contract. The floor ran. The day continued. The work was his. The Inspector General's report, when it was released 14 weeks after the formal inquiry, ran 112 pages. The sections that addressed AeroCrown occupied 37 of those pages, and the certification board analysis occupied another 18. The report found that AeroCrown had, in 6 documented instances over the preceding decade, engaged the certification body's review process in ways that reflected conflicts of interest on the part of board members who also held financial relationships with AeroCrown or its subsidiaries. The conflicts did not demonstrate that certifications had been granted improperly. but they demonstrated that the independence of the certification process had been structurally compromised in ways that the body's own governance rules prohibited. The certification board's chairperson resigned before the report was published, having seen the preliminary findings. 2 other board members resigned in the 2 weeks following publication. The Department of Defense issued a directive requiring that certifying bodies for defense-related aerospace components undergo an independence review every 3 years, and that all board members disclose financial relationships with companies whose components they were certifying. This was a reform that Shaw had been recommending in internal documentation for 4 years. The Magnolia response case had not been what finally produced it. That had been the AeroCrown findings and the political moment created by a $500 million contract being put at risk by undisclosed board conflicts. Shaw had not set out to produce the certification reform. She had set out to document what she had observed, which was pressure on the certification process from large contractors. The reform was what the documentation eventually enabled. She understood this distinction. The documentation was what was in her control. The reform was what the documentation made possible when the conditions were right for it to be possible, and the conditions had included Malcolm Vance refusing to sign a contract with language on page 17 and recording a meeting in his jacket pocket and calling from the parking lot. She had called him before he called her. That sentence, which Malcolm had found remarkable in the parking lot, was unremarkable from her perspective. Because she had known his coupling was involved in the AeroCrown contract, and had been waiting for the contract negotiation to reach the point where she would need to speak with him. The timing of his call had simply intersected with her readiness to make hers. Malcolm had said at one of the subsequent sessions with her team that he was glad she had been investigating. She had said she was glad he had recorded the meeting. He had said he was not certain that was going to be the thing that made the difference. She had said, "What made the difference was that you knew what page 17 meant. A lot of people wouldn't have known." He said, "My daughter read it in 8 minutes. Your daughter is an IP attorney. Most small manufacturers don't have that." He thought about this. He thought about the other 7 documented cases in the Inspector General's report. The 7 smaller suppliers who had signed the version of page 17 that they had been presented with, and who had spent the subsequent years watching their technology become progressively less theirs. He thought about what those cases looked like from inside, whether the people who signed had understood what they were signing, or whether the combination of Sutter's fluency and the hangar's architecture and the aircraft in the background had produced in them the impression that the language was standard, and that the room was designed for competence rather than extraction. He did not know. The report did not contain extensive detail on those individual cases, which were historical and were cited mainly to establish the pattern. But the pattern existed, and its existence meant that page 17 was not an anomaly in AeroCrown's contracting history, but a practice. And the practice had worked for years because the small suppliers it targeted had not had what Malcolm had, which was Naomi and the recording and Shaw already on the phone, and 29 years of watching Leon Vance build things carefully, and with an understanding that what you build is yours and yielding it requires knowing exactly what you are yielding. Jordan Miles, in the weeks after the board's announcement, had continued his work at Vance Precision without particular comment. He was not someone who expressed things except through the precision of his work, which was how Malcolm had first noticed him. He had come to the scholarship interview as a 25-year-old, with grades that were excellent and an affect that was quiet, and Malcolm had asked him why he wanted to work in precision manufacturing, and he had said that he liked things that were either right or not right, because if you knew the tolerance, you knew whether you were inside it or outside it, and he found that more reliable than fields where the standard was not specific. Malcolm had liked this answer. He had seen in it something that was not just engineering aptitude, but a particular relationship to honesty, the preference for measurement over impression. He had offered the scholarship and subsequently the job, and had watched Miles develop into someone whose judgment he trusted specifically, because Miles's judgment was always grounded in what the measurement actually showed. Miles's testimony in the Inspector General's inquiry had reflected this quality. He had been asked at one point whether he believed AeroCrown had acted in bad faith. He had said, "I don't have measurement for intent. I have measurement for provision language and what it would produce." The provision would have transferred effective development control of the coupling to AeroCrown over time. That's what the measurement shows. Whether the intent was deceptive is a question I can't answer with a measurement. The inquiry's attorneys had found this useful. Shaw had found it exemplary. She had told Malcolm after the session that Miles was someone worth keeping. Malcolm had said, "I know." The contract was signed in October. The coupling began delivery on the schedule that Malcolm's facility had been building toward. The first delivery was made on time. The second delivery was made on time. The precision with which Vance Precision Engineering manufactured the coupling was the same precision it had always had, because the coupling did not know that the morning in the hangar had happened, did not know about page 17 or the recording or the board's meeting. It was a mechanical component manufactured to specific tolerances that were either met or not met, and they were met, and the aircraft that incorporated them performed within the parameters the tolerances were designed to ensure. The Department of Defense contracting officer who reviewed the first delivery audit noted in her assessment that the component specifications were fully compliant with certification requirements, with measured tolerances within the specified range across all test parameters. She had not been present for the Inspector General's inquiry. She was reviewing a component. The component was what it was supposed to be. This was what Malcolm had built the company to produce. The morning hangar had been a test of whether what he had built could survive the pressure that comes when something valuable is made visible to people who want it. The company had survived because of the patent and the recording and Naomi and Shaw and Miles, and because of the 7 years of work that had produced the coupling in the first place, but also because of Leon Vance's tools in the display case by the door, which were there not as sentiment but as statement, the statement that the work was built on something that preceded the company and would outlast any single contract, and was not available on page 17 of anyone's agreement. The scholarship fund that Malcolm had established continued. In the year following the AeroCrown contract signing, it funded 3 students. 2 were from the county. 1 was from a neighboring county whose school system had a relationship with the trade association Malcolm served on. The 3 students were in their first and second years. They would graduate. Some of them would come to Vance Precision. Some of them would go elsewhere. All of them would carry, from the scholarship and from the company's presence in their county, an understanding that precision manufacturing was a field where the work was real and the standards were specific, and the people who did it well built things that mattered. One of the 3 scholarship students had come to the facility for a tour the previous month. Malcolm had shown her the shop floor, the machines, the quality control station, the display case with Leon's tools. She had asked about the tools. Malcolm had told her they were his father's, and that his father had been a machinist, and that the company had started in this building. She had asked if his father had worked for AeroCrown. Malcolm had laughed. He had said no, his father had worked for himself. She had nodded. She was 18 and had the specific quality of attention of someone who is deciding whether a thing is real. She looked at the tools for a moment. Then she turned to the shop floor and looked at the machines and at the people working. She said, "Is that what it looks like when you do it right?" Malcolm said. "That's what it looks like." She kept looking. She was deciding whether she believed it. She was deciding whether this was the kind of room she wanted to spend her working life in, whether the specific thing this room asked of the people in it, precision, care, the willingness to work within tolerances that had no room for approximation, was the thing she wanted to give her life to. Malcolm did not try to close the question for her. He let her look. He had been 18 once, and had stood in a room where work was being done carefully and had made a decision. And the decision had taken him here, and here was the shop floor and the coupling and the patent and the signed contract and the scholarship and the tools in the case by the door and the record of what had almost happened and had not happened because of everything that the room had always stood for. She was looking at all of it. She was deciding. He let her look. The machines ran. The tolerances were met, the work was his, and the company was his, and what he had built was built on something real and real things. His father had taught him, don't yield to paper. They yield to the people who build them better. Malcolm was the one building. He went back to the floor. The coupling itself was not a complicated thing to describe, even if it was a complicated thing to build. It was a mechanical joint, specifically designed to dampen vibration at frequencies that conventional couplings either transmitted or absorbed inefficiently. The engineering challenge had been finding a material configuration and geometry that could maintain the dampening effect across the range of temperatures and load cycles that aerospace applications required. Malcolm had worked on the problem for 3 years. in collaboration with a materials engineer named Patricia Chen, who was now Vance Precision's technical staff, before they arrived at the configuration that worked. The patent described the configuration in the specific language that patents require. Claims, dependent claims, drawings, specifications. Leon Vance had been alive when Malcolm filed it, and Malcolm had taken him to the patent attorney's office for the final review, because his father had never been in a patent attorney's office, and Malcolm wanted him to understand what was being protected and why. Leon had read the claims with the deliberateness of who was not a lawyer, but who was precise about language in the same way he was precise about measurements, and he had said when he finished, "So this paper says this is yours?" Malcolm had said yes. Leon had said, "Good, keep it." He had died 2 years later. The patent was still Malcolm's. The modification that page 17 would have imposed on that ownership had not been imposed, because Malcolm had known what page 17 meant and had called Naomi from the parking lot, and because of everything that had followed. The fact of the coupling's existence and its function and its protection was not in any single piece extraordinary. Patents were filed every day. Attorneys reviewed contracts every day. Recordings captured conversations every day. Federal auditors reviewed certification processes every day. None of the components of what had happened to protect Malcolm's invention were unusual in themselves. What was unusual was their combination in a specific timeline. The meeting in the hangar, the call from the parking lot, Naomi's 8 minutes, Shaw's call that was already coming, the inquiry, the recording, the board. The combination had worked because each piece had been there. The recording had been there because Malcolm had sat down in Ellison's office 6 months before and understood that a record would matter. The patent had been there because 3 years of work and 1 filing had put it there. Naomi had been there because Malcolm had raised a daughter, and she had become an attorney, and she answered her phone. Shaw had been there because the Inspector General's office employed people who investigated things even when the investigation had not yet reached the moment that would validate it. Each of these things was the result of someone doing something over an extended period of time. The coupling had taken 3 years. The scholarship fund had taken 7 years to produce students who were now entering the field. The Inspector General's investigation had taken 4 years to reach the documentation that the report contained. The patent had been maintained for 6 years. Naomi had practiced law for 12 years. None of this had been assembled for the morning in the hangar. It had been assembled for the work, which was the work of building a precision engineering company in a county where such a company would provide employment and develop local technical capacity and produce a component that improved the safety of aerospace systems. The morning in the hangar was what the assembled work could withstand. It had withstood it. The interim CEO who had signed the revised contract had, in a subsequent conversation with Malcolm, asked how he had known to record the 6-month earlier meeting with Ellison. Malcolm had thought about how to answer this. He had said, because Ellison was in the room and the room was arranged in a specific way. The interim CEO had said, "What do you mean?" Malcolm had said, "The chairs were positioned so that I was facing away from the window." When you're invited into someone's room and the chairs are arranged so that you're facing away from the natural light, someone has thought about how the room is going to work. I wanted my own record of how it worked. The interim CEO had thought about this. He had said, "That's a detail I wouldn't have noticed." Malcolm had said, "My father built things. When you build things, you notice how rooms are assembled." This was as close as Malcolm had come, in any of the subsequent conversations, to explaining the underlying source of what had protected him. It was not the patent alone, or Naomi alone, or the recording alone. It was a way of seeing that had been built into him by 29 years of watching someone who worked with precision and care, and who could look at a room and understand how it had been assembled, and who had taught him that the assembly of things told you what they were for. The hangar had been assembled to impress and to position. The presentation had been assembled to move quickly through the parts that were straightforward and quietly past page 17. The chairs had been assembled to face the full length of the hangar and the aircraft in the background. All of it had been assembled for a specific outcome, and Malcolm had sat in the room and read its assembly the way his father had taught him to read the assembly of things, and he had understood what it was for. Understanding what a room is for is not sufficient to protect yourself in the room. Malcolm had also needed Naomi and Shaw and Miles and the recording, but the understanding was the beginning. The beginning was where everything else had the chance to follow. Patricia Chen had continued her work on the coupling's material specifications in the years since the patent filing. The certification required that the specifications be stable, but within the certified range there was room for optimization, and she had found improvements in manufacturing consistency that did not change the component's fundamental design, but reduced the rate of out-of-tolerance production runs from 3% to less than 1%. This was a meaningful improvement in a production context. It meant that fewer components were rejected, which meant lower material cost and higher throughput, which contributed to the company's margin in a way that compounded over the volume of the AeroCrown contract. Chen had presented the optimization findings at a technical staff meeting the month after the contract was signed. She had presented them in the way engineers present findings, with data, with the measurement of the improvement, with the caveats that applied to the dataset's size and the conditions under which it was collected. Malcolm had listened and asked questions, and at the end had said, "File for the supplemental patent." Chen had said, "It's not a significant enough change to." Malcolm said, "File for it." She had looked at him. She understood. The improvement was theirs. The record of its ownership needed to exist before anyone else had the opportunity to suggest that it might be theirs instead. That was the lesson of page 17, applied not as a defensive reaction but as a practice, the practice of keeping what you built in a form that could be defended, because what you built was worth defending. The supplemental patent was filed. It was recorded. It was theirs. The scholarship student who had toured the facility did not immediately decide. She went back to school. She called Malcolm 3 months later and said she had been thinking about the floor and the display case and the questions she had asked, and she decided she wanted to come back the following summer for an internship. Malcolm said they would arrange it. She came back the following summer. She worked on the floor in the quality control station, learning the specific relationship between measurement and outcome that was the foundation of what Vance Precision produced. She was careful and asked good questions and made 2 mistakes in the first 2 weeks, and came to Malcolm with both of them, reporting them before they were caught, because she had understood that the company's relationship to measurement applied to its own performance as much as to its components. Malcolm had said, "That's exactly right." She had said, "What do you do with the reports?" He had said, "We keep them. We analyze them. We figure out whether the mistake is a person mistake or a process mistake. Then we fix it." She had said, "What if it's a person mistake?" He had said, "We train. If training doesn't fix it, the person and the role might not be the right match. But most person mistakes are process mistakes that the person is absorbing. We look for that first." She had thought about this. She had said, "That's more careful than I expected." Malcolm had said, "The coupling goes into aircraft. If it's wrong, people notice." She had understood. The stakes clarified everything. If the component was wrong, people were at risk. That was why the tolerance was specific. That was why the measurement was honest. That was why the records were kept and the mistakes were reported. And the process was examined when the people were absorbing something that the process was producing. She stayed for the full summer. She came back the following year. She was good at the work, and she was going to be better. On the day she left at the end of her second summer, she stopped at the display case with Leon's tools. She stood in front of it for a moment. She said, "Those are old tools." Malcolm said, "1970s. My father bought them when he started his own work. Are they still usable?" "For what they were made for, yes." She looked at them. Then she looked at the shop floor. Then she looked at Malcolm. She said, "I'm coming back." He said, "Good." She left. The tools stayed in the case. The floor ran. The coupling was made to the tolerances that the certification required, and the improvement had reduced the production loss rate to below 1%. And the contract deliveries were on schedule, and the patent was filed, and the record was maintained, and the scholarship was funded, and the work continued to be what it had always been, which was real and his, and built on something that preceded the company, and would outlast any single agreement. Real things don't yield to paper. They yield to people who build them better. Malcolm Vance was building. The work was his.